Hello everyone, welcome back to our channel. In today's video, we are discussing on NCLAT judgment. It was held if a successful resolution applicant fails to implement an application plan in prescribed time limit, the performance bank guarantee can be invoked and the Corporate Insolvency Resolution Process or CIRP can be revived. This decision reinforces that timely implementation of resolution plan is not an optional, it is a fundamental to the objectives of the IBC. We'll see the background of the case. This case arose out of Lavasa Corporation Limited insolvency proceedings. The resolution plan submitted by SRA was approved by the Committee of Creditors with a massive 96.41 voting shares, and subsequently NCLT approved the plan, and under the terms of the plan, SRA had to infuse 100 crores upfront within 90 days of the effective date and had already furnished a performance bank guarantee for 25 crores. The monitoring committee was also formed. Then default by resolution applicant. However, despite more than 409 days passing after the effective date, not even the first tranche of the payment was made. So the lenders, in their joint lenders meeting on 6th April 2024, unanimously decided that SRA had failed to implement the plan and directed Union Bank of India to invoke the performance bank guarantee. Accordingly, performance bank guarantee was encashed. Union Bank also sought revival of CIRP before NCLT. Then argument by the appellant, SRA. SRA argued the successful resolution applicant contended that it was prevented from implementing the plan due to litigation initiated by the lender themselves, including the appeals and recall applications before high courts. It argued that invocation of PBG, performance bank guarantee, was unjustified. Then COC's counter argument. The Committee of Creditors opposed this, finding out that there was no stay order or injunction that prevented the SRA from making the payment. They emphasized that timely implementation of the resolution plan is the very foundation of the IBC, as delays only result in asset erosion of the corporate account. So now we'll see the findings of NCLAT. The Appellate Tribunal carefully considered the matter, and it noted that SRA had failed to deposit even the upfront amount despite the clear timelines in the resolution plan. NCLAT held that invocation of performance bank guarantee by Union Bank entirely valid and was in line with the regulation 36B 4A of IBBA CIRP regulations. The tribunal also observed that the appellant's plea for more time lacked bona fides as it did not specify any definite timeline for making payment. Supreme Court President NCLAT referred to Supreme Court's ruling in State Bank of India and others versus the consortium of Mr. Murari Lal Jalan and Florian Fritsch, where the apex court made it clear that the timely implementation of a resolution plan is a core object of IBC. Any failure in this regard undermines the court's purpose and leads to loss of value of the stakeholders. So the final judgment is, accordingly, the NCLAT upheld the NCLT's order, which had allowed Union Bank's plea for invocation of PBG, performance bank guarantee, and revival of CIRP against Lavasa Corporation Limited. So both appeals filed by successful resolution applicant were dismissed. So here the takeaway is strict timeline in resolution plan are non-negotiable. Failure to comply allows lender to invoke the performance bank guarantee PBG. CIRP can be revived if SRA defaults on implementation. IBC prioritizes speed and certainty to preserve the corporate data's value. We have two channels, RR Corporates, other channel RR Legal Tax. Please do subscribe and hit the bell icon so that you will not miss any of latest videos. Thank you.